Juanita, welcome.
Hello, Mark.
Apologies to everyone if you've been sitting there waiting for the last 5 minutes. We've had some technical difficulties. Houston, we had a problem, but anyway, we've got it all fixed now. So welcome everybody. Welcome, Juanita. And
Thank you.
It's a beautiful, beautiful rainy day outside. Thank goodness. It's storming outside. There's lightning and everything. But so what we talked about last week was the gist of what happens with estate and succession planning, the sort of the underlying, I guess, issues that come up. We talked about all the dangers last week. And so today we want to kick off and talk about some of the strengths that people have as a result of going through this and paying attention to it. So the first one is, like, people that are sitting and listening to this at the moment are actually in what we call a privileged position, and that is that they're in a financial situation. They've got they're mentally capable, and they've got the opportunity to put together something that's orderly, prepared, and logical for their estate transition. So a lot of times, and I guess you would have seen this, Juanita, is that people aren't in a privileged position because either they've left it too late, and or they're not of mental capacity to do what they want to do, or the fights have already started in the family. So do you want to touch on some of the examples that you've seen where, things have gone bad?
Yeah, certainly, doing things and putting things in place while you can is the best opportunity as such. What we often see is people wanting to put their estate planning in place when things go wrong, or when they've been perhaps they've been diagnosed with an illness, and so of course then decisions are made under somewhat of a pressure point. When you've got other things going on, it's difficult to think clearly. There's lots of other things affecting your decisions. There's in some cases not much time left. So also when someone loses their capacity, their mental capacity, be that in an older age or if they've had an accident, then it's simply too late. So there's nothing that can be done then. Well, there is, but it's a lot more expensive and not very simple. So that's not a great solution also. And as you say, obviously, sometimes there's already squabbles or issues in a family, and not having that setting out the plans and talking through things right at the start, that can sometimes avoid getting to that stage. So, for all the above reasons, it's a really smart decision to put your estate planning in place while you can, while you're thinking clearly, while you're young, while everything's good. That is the best time, when you least need it, obviously, but it is the best time to put it in place.
Well, we never know when we're going to need it, I guess. So,
yeah.
and that's the point. But for example, I've just got off the phone to someone up in North Queensland, hence why I was running a little bit late. But they're in a situation where the horse is kind of bolted. The kids are already starting to have conflict with each other. They've sort of, Dad wanted to go and buy some stuff, and because he's brought the kids in and hasn't set up the documentation properly, they outvoted him on some issues, which really have hamstrung him to a certain percentage. So it just keeps, as he kept saying to me over and over while we were having the conversation, he said, "Oh, gee, I wish we'd met you guys years ago and we could have structured this properly back then." So the time to do it is when, you said it before, the time to do it is when you don't really need it. The time to do it is before you actually feel that you need to have it done.
And that goes with succession planning as well as estate planning, I guess. So it's not only, the estate planning, which is for after death, it's succession planning, which is during your lifetime, how to pass on the succession of your business and wealth perhaps during your lifetime. So, again, another reason to put that in place before things start getting tense, so everyone's well aware of the plans.
Absolutely. Now, one of the other things in regard to the advantages, so we're talking here about the strengths that you already have in place, and one of those is to have in place what we call a tactical team. Now, a tactical team is your team of professionals that are going to work together well to help achieve your goals, and each of them. And if you do this in a smart way, I guess what you do is find people who have unique strengths in each of the areas that you're trying to help utilize in regard to your estate planning and so on. So, generally speaking, a tactical team might involve, obviously a good lawyer, your accountant, financial planner, maybe a share broker, and other professionals, and obviously in conjunction with someone like myself, the facilitator for the whole process. But you really need to have a good team of people together. It's not a role for any one occupation. And someone was going through some issues with me this morning, and just reflecting on how many times, and this is not an accountant bashing exercise by any means, but the number of times that clients feel that their accountants are the ones who are best positioned to help them in regard to their estate planning, their succession planning, and so on. And I'm just going to say that accountants play a really, really special and important role in your estate and succession planning, but no one profession by itself can do all that needs to happen for you to get your estate and succession planning done. I mean, the accountants are a very important part of it, but they can't do the legal documents. They can't do the wills. They can't do any legal documents that need to be done along the way. And generally speaking, they're not necessarily the ones that are good at facilitating. 9 times out of 10, they're not the ones that are the financial planners and so on. So you really need specialists in each area. And we come back to the analogy, if you had a brain tumor, you'd go to a specialist, you wouldn't go to a GP. But very much so, it's all your professional advisors working together, not any one by themselves.
Yeah, one of my pet topics, and often I said are afraid that just is going to be very expensive, having all these professionals working for them. But the reality of the fact is that of the situation is that it actually makes things more efficient, which can reduce expense. So being able to pick up the phone for us as lawyers and talk to your accountant or your financial planner, who will have a really solid understanding of the information we're looking for, which the client might not always have themselves, understandably so, just makes things so much more easier and efficient and quicker for us to work. So it doesn't mean more expense. And probably another potential member of the team that I'd add, Mark, to that is someone you respect in your business. So, for example, we might see some rural clients that have the farm, etc., and they might put someone in their team that if they pass away, they want their family to consult, because that person they respect and is an expert in that particular business area. So another handy part of the team also.
Look, absolutely. And, I think I may have mentioned this before in a previous one, but when I was doing a lot of work in the motor industry, we used to talk about, who's a non-competing dealer, someone out of one of their comparison groups or whatever, that if the principal of the dealership died and the kids weren't at an age where they're sort of proficient enough to take over, who's a non-competing dealer, a similar sized dealership that they respect, that can come and help the children during that transition period, either while they're selling it or just to help them build up the capability to take over. And it's exactly the same in the rural industry as well. I mean, if the kids aren't old enough or don't have enough experience, whatever, very, very important part of the whole process is to make sure you've got someone there that helps them along. The other thing I was just going to say too, Juanita, and you'd understand this, I always say to clients when we start working together, is say, let's you and I have a conversation in plain English, and then we'll go and see the lawyers. Before it gets too technical.
I understand, yeah, but I must say, fun fact, that the lawyers these days and legal writing, etc., is moving towards much more plain English. So, when we do a will these days, probably 10 years ago, it had all sorts of fancy words, etc., and used really old English sort of sentences. But these days, there's a tendency just to make it plain and clear, so anyone can pick that up and pretty much read it and understand what it's saying.
Herewith and therefore and thereafter and all those
we don't
good
use
words.
that very much anymore.
Don't use those anymore. That's good. Okay. The third thing is one of the strengths that you have by doing this now and not leaving it too late is that, you know, you have the opportunity to make sure that the intentions that you want for your family, the intentions you want for those that you love and those that you care for, are honoured. So you can start with the proper intent. And in a lot of ways, a lot of times too, this is a reflection of, I guess, the questions you're asked when you start going through this process. But I like to refer to this as fostering the grace and integrity to ensure that your plan is proper for those that you love and those that you care for. So making sure your intentions are reflected as part of the document. In other words, you're not just going to a professional advisor who just says, okay, we'll grab a precedent off the shelf and we'll just put in your name and details and all that sort of stuff. It's all about having the communication and the conversations to 11 minutes, 15 seconds. The communication and conversations to make sure that what your heart is saying is what ends up in the documents.
Yeah, we've spoken before about reasons why it's not advisable to do things like home will kits, etc., because your intentions might not actually get put in place due to your own unknowing error. So while you've got the opportunity to get that advice and put everything that you want in place, then that's a fantastic opportunity to have that not everyone does.
Absolutely. The next one I call the legacy solution, and I'm just going to go back and have a bit of a background on this. One of the questions that I often ask people is, you know, do you want to be in a position where your debts outlast you? So, you know, think about someone's gone out and borrowed $2 million to buy this or that or something else. So I always ask the question, you know, do you want your debts to be extinguished when you go, or do you want to pass your debts down to the next generation? And for some people, that may be appropriate. For others, they may want to pass on to their spouse, for example, a home that's free of debt, and as much as they can to eliminate debt that's, I guess, bad debt or unnecessary debt. So what we do is talk to people about making sure their debts don't outlast them, and sometimes, and that can be through the use of life insurance or whatever, but also many times when people pass early before their due date, so to speak, or their vesting or their anticipated age of passing, they haven't had time to build up the estate that they need to be able to keep the promises that they have to their family. So they might have promised that, you know, their spouse was going to get the home debt free. You know, all the business debts were going to be paid off. There was going to be an education fund for Johnny and Sally to make sure they could go to private schools and have the education they wanted, and so on. So a lot of times, life insurance, for example, is a very, very good tool to be used to maximize the estate, to allow you to be able to keep the promises, to fund the promises that you've made to members of your family, be it the children, your spouse, whatever. Time's up. You've got to wave your hand again for the lights to come on. But so legacy maximization is a very important part, as I say, especially when people pass away early, and just to make sure that the promises you've made are going to be honoured. So any thoughts about that?
Yeah, well, definitely how a will is drafted, for example, can dictate whether a debt carries with an asset. So if you have a mortgage over a property, depending on the drafting, it will. Often we'll put things in place in the will where mortgages or specific debts can be paid out by, as he suggested, the life insurance or the super, which might help a spouse that's left behind. And, you know, another sort of tricky thing too is often loans and assets will be held in different entities or names. So it's really important to be really clear on those things and make sure that the debt and the asset passes, you know, to the right people or doesn't pass to the right people. So yeah, just definitely having that clarity and understanding of and it all comes down to how the will's drafted and what your intent is, as you said.
Yeah, very much. I'm just going to skip now to number 6, which is a tool, I guess, that we've put together. We used to call it the Legacy Efficiency Score, and now we call it the Will Score Online. And actually, you can go to that website, just Will Score, one word, .online, and basically it'll ask you a whole lot of questions, and it'll give you a score in regard to what have you put in place already, and how efficient is that in regard to the needs and aspirations that you have. So it's just an online tool which will hopefully ask you some questions and get you thinking about things you hadn't considered before. I don't know if you've had a look at it yet, Juanita, but
I haven't. I've written a note down, so I looked that up straight after this. And you know what? I bet we never see anyone with a 100% score. There's always, unless they've come and seen us and they finished.
Only people who have been to us already that get the 100%.
But if you're starting the process, very rarely, if ever, will you be in a position where you've got 100%. So you can see where the gaps are, where you would obviously need to plug in the holes with your estate planning.
Yeah. Okay. One of the other tools that, one of the other concepts. So now we're going to opportunities, I guess, and the greatest opportunity you have when you're doing this now, and it's a bit like talking about the privileged position before, and that is you can set up what we call the right cubed ideal, that the right money goes to the right people at the right time, so that you've created harmony, certainty, confidence, security for your family, your business partners, all your beneficiaries, and so on. And just remember that it's not just about having the right amount of money when we talk about the legacy maximizer and so on. It's making sure the right money is there for the right people at the right time, and that includes making sure your beneficiaries are up to date. We talked the other day about, for example, on your life insurance policies and so on, making sure you've nominated the correct beneficiaries there. With your superannuation funds and so on, each 3 years, I think it is, you should be doing binding death nominations for your retirement benefits and so on. I'm going to go back and say again, look carefully at who the beneficiaries of your life insurance are. And sometimes it's not the beneficiary, it might just be the owner of the policy. You might be the life insured. Someone else might be the owner of the policy, and it could be an ex-spouse or could be an ex-business partner or whatever. So make sure you check the right money is going to go to the right people and at the right time. And that's where we've talked before about, these days it's more likely 30, 35 people are saying give money to their children, not 18 and 21 like it was probably 20, 30 years ago.
Again, it comes down to how the will's drafted and how the estate plan is set out. But the legal age for a beneficiary to take their inheritance, whether through a will, is 18. But you can certainly specify older ages, and most people think 18 is too young for an inheritance. So
especially
you
these days.
Put some thought into that. It's also worth understanding that if your super, for example, goes directly to a beneficiary, then they just take it outright. There's no age limit there. So there's things you can put in place to allow that to flow through your estate and get to the right person at the right age in particular.
Yeah. Okay, one of the next opportunities we're talking about is, and this is one that we always put up for our clients, is to have an electronic vault where all the important documents are kept, so that your executors, when they need to, the key people in your life, when something happens to you, everything is in one place, so they can go to a central repository to just get access to copies of wills, enduring powers of attorney, buy-sell agreements, all the other guardianship agreements, and so on. So I know you're going to say, Juanita, you need real copies of things as well, but I think from a practical point of view, to at least have electronic backup is certainly going to help people at their greatest time of need.
Yeah, certainly all original documents, important original documents, we hold for our clients in safe custody, as do most lawyers, as well as electronic copies. But we'd also always send electronic copies of fully signed documents like wills and enduring powers of attorney and trust deeds to our clients. And it's a good idea for yourselves to keep all those documents in a folder in a one place, as well as your solicitor account, and having those documents, because my gosh, if something happens and your executor or your attorney need to access those documents, it can make such a huge difference just being able to easily access everything you need together than scrounging around trying to make phone calls, sending emails, trying to find documents. A lot of people are surprised by the fact there's no common will register. So there's no way you can go to find out if someone's got a will. They're not required to be registered anywhere. There's, different places you'd investigate, that we would investigate knowing what we know. But certainly you don't have to register a will anywhere. So it's really hard if you don't have those documents all together and have told your family or your executor or attorney where they are to actually find them.
I think there's a huge opportunity there, Juanita. I reckon a great entrepreneur could these days set up a will registry and go around to all the legal firms and say, here we are, let's upload all these wills. And because that must be a real problem for people when someone passes, wondering whether, who's got the most current will. Did the deceased go and visit some random lawyer and not tell anyone? I think it'd create a lot of peace of mind if, anyway, that's for an entrepreneur who's listening to this to go away and do that. One of the other opportunities we often talk about, and this is probably one of our most famous tools, capabilities, frameworks, whatever you want to talk about, is whatever you want to call it, is the Dear Mary letter. And interestingly, when what we found is when any of our clients pass away, the first thing the spouse asks for, it's like they ring us immediately, more so than to tell us that their partner has died. They say, have you got a copy of his dear or her Dear Mary letter? Which is really, it's the great thing about this is it's a document which really allows words to not be left unsaid. So it allows you to write letters to your spouse, to your children, to those that are important to you. It allows you to tell them who to trust, who to avoid, what do you own, what do you owe, what do you want done with certain assets and so on, and what you'd specifically want for each one of those that you and love and care for. So your Dear Mary letter is actually the most personal and appropriate, I guess, and most important document you can leave behind for your family. And just before you say something, Juanita, I'm just going to say each year now I actually I use my iPhone and I just record it, voice record, just on notes and so on, and I send it off to Gabriel, who then puts it in the vault for me. And I sit there usually with tears running down my face, dictating love notes to all my family members, brothers, sisters, mum, children, grandchildren, and so on. And just I want them to hear my voice saying the things that I'd never want left unsaid for each of them. And the reason I think that's so powerful, probably even more so than for some people, they might prefer it written. But, the interesting thing I've noticed when people have passed away is that what happens is people go back to their phone and they keep listening to the message bank of the person that's deceased. They just want to hear their voice. And so they keep ringing the phone number to hear the voice. So I think anything that you can do to leave a bit of yourself for those that you love and care for is a good thing. And the Dear Mary letter is a great way to do that. Whether you write it, whether you record it, or whether you actually video it, that's up to you. I didn't want to video myself bawling my eyes out, so I just recorded it.
Yeah, no. A couple of thoughts. I suppose just to. Oh no, you're not crying now, are you, Mark?
No, I'm not crying now. I've just got something in my eye. I promise. I promise they're not sweating.
It's really important to distinguish this as from your will and what you want to leave into to who. So this is the stuff that doesn't go in your will. So in this letter or in this recording, we're definitely not talking about what you want to leave and to who. That goes in your will. Please don't do other documents and pieces of documents and recordings that say that. But it's the extra bits. So it's like the who to talk to, who to trust, things that you want to say that don't go in the will. So personal messages, what your hopes and wishes are. So that sort of stuff, most definitely. And when we do estate planning suite of documents for clients, we'll often include letter of wishes to the guardians of your children. So you can put down what your wishes and hopes are for your children, but not just fancy, just sort of pie in the sky stuff. Also things that are really practical, like what your beliefs are and what sort of schooling and education you would want your child to have. So that's really important stuff that as guardians, bring your children up if need be, that they'll, sort of wonder what decisions to make. So that's very helpful. And also, you know, if you've got a more complex estate, just being able to give your trustees and your executors some guidance as to how you would run your business or how you would run your trust and what your wishes are there. So very, very useful documents. The little extras that go with it.
Sorry, say that again.
The little extras that go with your will.
Well, absolutely, and this is what I call the human elements of the will, and I know you keep bringing it up and reminding people, but it's very true. This isn't the legal document. This is all the heartfelt stuff that's not in the legal document, but this is the stuff that a lot of people find, you know, more valuable than anything else. So highly recommend you take the time to include that as part of your whole process, and it's a great opportunity for you to do it now. As I say, I update mine every year, and so that it's, you know, never going to be more than a year old, the words that you want to say to those that are left behind. The next opportunity you've got is to create family consensus, and I think that's just very simple, but probably one of the most important things is to make sure you're in a confident position where you've discussed and had communication with all the members of the family, and you understand what their wants, their outcomes, their needs, their desires are, and you're able to maybe craft your estate planning process in such a way that takes into account what is best going to create consensus for all those that are left behind. So this is a very important part of the process, because, and certainly in what we do in estate planning, succession planning, is to make sure there's no squabbles after mum and dad have passed away, or hopefully before they've passed away, there's no squabbles. And it's getting everyone on the same page, getting an understanding, focusing on gratitude, and understand that what mum and dad leave is a gift. It's not an entitlement or an expectation. It's and getting a consensus with everyone in regard to who's going to take over the farm or the business, and how other people are going to be taken care of in different ways, but in a way that's fair. So that's
it's a great opportunity to have the ability to have input while you're still alive into reaching that consensus. And for some people, you know, we get that it's difficult to have those conversations, and that's where your self-mark comes in and can really facilitate and help that, rather than leave those conversations, those hard conversations unsaid until afterwards, until it's too late.
Absolutely. Look, one of the last ones I'd like to touch on here is just a couple more after this, is what we call, I just tagged this, the blissful unawareness checklist. And this is kind of reflecting back on the fact that people don't know what they don't know. And so we have a bit of a checklist with our clients we go through, and we call it the blissfully unaware checklist, because most people are blissfully unaware of things they don't know. So it's a checklist for when you think that everything's okay. And it's a way for us just to make sure that all your bases are covered, and that you've been given the opportunity to make decisions about things that you may not have even thought were relevant, appropriate, or even possible for you to do in your estate planning. And I think, Juanita, you'd find this all the time, that you know, the greatest issue is people are unaware of what they can do, and that's where our value is the greatest.
Absolutely. I couldn't have said it better myself. You know, a lot of people don't understand.
I was giving you the chance, but, you know.
Yeah, basic concepts. You know, we've spoken before how a lot of people don't realise some assets aren't left in your will. They're outside your estate, what to do with them. Then, you know, as you said, as we spoke before earlier today about debts and assets passing, you know, all that sort of stuff. So you're not expected to know that. That's where professionals come into place. And, if you don't know what you don't know, absolutely. That's why we're here.
Yeah. And just to finish off before our time is up, there's three. These are what are called negative saboteurs, and the first one is the deferral dilemma. It kind of ties in with the invincibility delusion we've talked about before, where you have a tendency to keep putting off taking action or allocating effort towards a beneficial result, and invincibility delusions, the fact you always think it's going to be the other guy that catches the bus before you. The second one is what we call the frugal fault. I'm going to tell you, the work I do, the work Juanita and her firm do, it's not inexpensive. It's not cheap by any means, and in any definition of cheap, but it's appropriate. But as I say to people, you know, an ounce of prevention is where you need to start from here. It is going to cost you money to get this done properly. If you've got a decent sized estate, I'm going to tell you now, what it costs you on this end is going to be about 10 or 20 times more expensive if you don't do it, and your family has to unwind everything and stop the fights at the other end. And the third thing, and I just want to touch on this just carefully here, is what we call the territory trespass. And I put this in because a lot of times, and I don't find it as often these days, but a lot of times existing professional advisors really feel like you're cutting across their lawn when I turn up and talk to people about facilitating the team of professionals to get the job done. And 99 times out of 100, I want them involved in the process. I need them involved in the process, and I want your existing advisors to be part of what we're doing. But sometimes we turn up and other advisors, certainly not Juanita's firm, Murdoch's, but other advisors will get very jealous and sensitive and will try to push us away. So just be aware if one of your advisors doesn't want someone else to come in and give a second opinion, that should be a red flag for you in regard to why is that so. And in a lot of cases, it's because they're concerned they'll be showing up for not having fixed this for you in the first place. So they're the three saboteurs: the invincibility, the deferral dilemma. This isn't going to be a cheap or inexpensive exercise. It's valuable. If you had a brain tumor, you'd know you were going to invest good money to get life-saving treatment and so on. So they're some of the things, as we talk about in our GIST booklet or our document. They're the gist of the matter. And when you're looking at your estate and your succession planning, all the things we've talked about over the last couple of weeks are really important parts of the process, and I hope you take them all into consideration when you're looking at getting everything done and getting it done well. Because you've got a lot of money, you've got a great estate, you've got great wealth, and you want to make sure that it's protected through the generations. So that's it from me, Juanita. Any other closing thoughts?
No, I couldn't have said it better again.
Oh, yes, you could. If you tried, you could have. Anyway, thanks everyone for coming along today. It's fantastic to have the interest we have in these sessions, and we hope they're valuable for you. We'll see you next week.